All right, gentlemen transcriber, are you now ready to begin? Have you resolved your issues there? Very good. The tribunal secretary will join us momentarily. With your permission, we'll start without her.
Certainly.
That's all right with you, Mr. Keogh?
Yes, it is, Mr.
Very
President.
good. So then please begin. Thank you.
I will ask then, I've handed out a binder type of documents, which you're going to have to now look at. I can't put them up on the screen until I think they hit a button.
Sizable one.
Yeah, exactly. So, Mr. President, members of the tribunal, thank you. The claimant will address the four main issues in the following order. I will begin the presentation for claimants today by addressing the additional language that Renco included in its written waiver, by which Renco noted that it was reserving the right to bring claims on the merits in a different forum if they are dismissed on jurisdictional or admissibility grounds in this arbitration. That language is compliant with and consistent with the scope of the waiver provision in the treaty that required the claimant to provide, and that the claimant did in fact provide in both its request for arbitration and its amended request for arbitration. In other words, Renco did not and does not reserve the right to do anything in connection with that statement more than the treaty's waiver provision already allows it to do. That is the nub of the question in the scope argument. Now, I know we have a rebuttal, but I will respond very briefly to a point that I heard this morning, which was, if it didn't reserve more than what the treaty already provides, why isn't Renco just striking it? It must mean something if it's hanging on to it so tightly. The answer to that question lies in the fact that Peru has not raised this formal defect issue until long after the procedural order number 1 and we got their 1024 submissions. We had no idea that they objected to this formal defect until then, which was just recently. We did understand that they objected to the local bankruptcy proceedings in connection with waiver, but we had no idea that they would take issue with a reservation of rights that the treaty allows anyway, that is just superfluous. So if we could, with assurance, strike the language now, with assurance that Peru would not then bring another claim such that we're now in breach of the statute of limitations, we would strike it. It is superfluous. So it is wrong for Peru to argue that because we're hanging on to it, we must have some ulterior motive, and it must mean something when we're telling you it doesn't, and I'm going to show you that it doesn't do anything more than the treaty allows. But as I say, if Peru would commit that no harm, no foul, no statute of limitations issue, we would quite gladly strike it because, as I say, it is superfluous and it does nothing more than what the treaty allows us to do in the first instance, which is why your scope decision is so important. And we would, of course, object to statute of limitations. We would raise issues. But that's the reason we're not striking it and have not already stricken it. After I finish, Mr. Weiss will next demonstrate that even if there is a formal defect in the written waiver, which there is not, and I'm going to show you there's not, Renco should be given a fair opportunity to cure it. I will then take the microphone back and address Peru's de facto enterprise claim. Renco has brought all of its claims against Peru on its own behalf for damages to Renco. These claims relate to both the St. Louis litigation, in which Doe Run Peru is not even involved, it's purely Renco and other affiliates, as well as Peru's mistreatment and expropriation of the enterprise Doe Run Peru, which has caused Renco itself harm that is recoverable under the treaty. The treaty expressly allows a claimant to bring claims on its own behalf for damages to itself, and the treaty expressly does not require submission of a waiver for an enterprise when the investor only brings claims on its own behalf. Accordingly, Renco did not violate the treaty's waiver provision by not giving a waiver for Doe Run Peru. I will then turn the floor to Mr. Burnett, who will address the Doe Run Peru insolvency bankruptcy proceedings. As you heard this morning, Peru argues that Doe Run Peru's actions should be attributed to Renco, and that defending against Peru's $163 million credit claim violates the waiver that Renco provided. And Mr. Burnett will show you why both of those propositions are incorrect. I may or may not have a brief closing remark, depending on how much time remains. Okay, Mr. President, members of the tribunal, turning to the first issue, which is the scope of the treaty's written waiver requirement. I'll provide a brief overview now of the main points, and then I'll address each point in more detail. And I do ask, and I know you will, to please stop me and ask me any questions along the way. The scope of the treaty's waiver provision is a question of treaty interpretation. The question for this tribunal is whether the language that Renco added, that I've highlighted in yellow, purports to reserve to Renco a right that the treaty requires Renco to waive. And when the tribunal interprets the treaty, you will conclude, just as the tribunal in Waste Management 2 concluded, that the treaty does not require a claimant to waive rights to bring claims on the merits in a different forum if this tribunal determines that it does not have the jurisdictional authority to hear the claims on the merits. And there are 5 reasons for this conclusion. I'll list them now, and then I'll review them in more detail in my argument. The first is the object and purpose of the treaty's waiver provision is to prevent inconsistent results, double recoveries, parallel proceeding, multiple proceedings. None of these goals are furthered by barring a claimant from having the merits of its claim heard in any forum whatsoever. Second reason, the object and purpose of finality in international arbitration is to obtain an award on the merits of the dispute. If the merits have not been reached for jurisdictional reasons, there is no finality. Third, the object and purpose of the arbitration provision in the treaty is to create effective procedures for resolving disputes, not ineffective ones. Interpreting the treaty as Peru proposes here would leave a claimant with no forum at all. A claimant who is found to have waived any possibility of a local remedy, but then later finds there was no jurisdiction at the international level, would be justified in questioning the effectiveness of the international procedures. And as I mentioned, I'll be reviewing this in more detail along with the other points in a moment. Fourth, Renco's interpretation of the scope of the waiver is consistent with customary international law. Peru's interpretation is inconsistent with customary international law. There is no rule under customary international law which provides that dismissing a claim on jurisdictional grounds constitutes a waiver of underlying rights associated with the dismissed claims. If the treaty had intended to derogate from principles of customary international law, the treaty would have stated so clearly, but it does not. And the fifth and final reason that Peru's interpretation is incorrect is that it doesn't count for the treaty's structure and text itself, and it would lead to a manifestly absurd result. Under Peru's logic, Renco is bound by a written waiver that is a condition precedent to the creation of an arbitration agreement, even though an arbitration agreement would not exist for the claims that the tribunal will have hypothetically dismissed on jurisdictional grounds. And that can't be the result. It is not a logical interpretation of the treaty's text. And I'll explain this in more detail in the main body, but what I'm saying is the arbitration agreement is the only basis for this tribunal's jurisdiction. If claims are dismissed for lack of jurisdiction, say you find that Renco is not an American citizen or there is no investment agreement, that means the tribunal will have found that there is no agreement to arbitrate between Peru and Renco. Peru never accepted Renco's offer, although Renco gave a conditional waiver together with that. The agreement to arbitrate cannot bind one party and not the other. Agreements don't work that way. Or stated differently, a non-existing arbitration agreement with respect to claims that you dismiss on jurisdictional grounds cannot deprive the claimant the underlying rights that it possesses with respect to those dismissed claims. The state can't have it both ways. And I'll get into that in more detail with the text of the treaty. That concludes my overview. As I mentioned at the outset, the scope of the treaty's waiver provision in Article 1018 is a question of treaty interpretation, and of course the rules of treaty interpretation under customary international law are codified in the Vienna Convention law on treaties. Article 31 of the Vienna Convention provides that a treaty shall be interpreted in good faith with the ordinary meaning to be given to the terms of the treaty in their context and in light of their object and purpose. Article 31 further provides that the relevant rules of international law shall be taken into account when interpreting the treaty. Article 32 provides that one should not adapt or adopt an interpretation that leads to a manifestly absurd or unreasonable result. Now, turning to the first of the 5 reasons that I outlined as to why Peru's interpretation is incorrect. International tribunals have held consistently and uniformly that the object and purpose of the waiver provision is to prevent inconsistent results, double recovery, multiple and overlapping and parallel proceedings. We see this in at least the following awards. The first one I have on the screen, Waste Management 1, noting that NAFTA's waiver provision, which is Article 112, is designed to prevent double benefits in claims for damages. Waste Management 2, no doubt that the concern of the NAFTA parties in inserting Article 112 was to achieve finality of decision and to avoid multiplicity of proceedings. International Thunderbird Gaming versus Mexico. The specific purpose of 1121, the waiver provision, is to prevent a party from pursuing concurrent and domestic and international remedies, which could either give rise to conflicting outcomes and thus legal uncertainty, or lead to double redress for the same conduct. RDC versus Guatemala. This interpretation respects the rationale and the purpose of the waiver, which is to avoid conflicting outcomes, double redress for the same measure. In non-disputing party submissions in investment treaty arbitrations, the United States, Mexico, and Canada have all confirmed their same understanding of the object and purpose of the waiver provision. We see this first in the submission by the United States of America in Detroit International Bridge versus Canada. The purpose of the waiver provision is to avoid the need for the respondent to litigate concurrent and overlapping proceedings in multiple forums and to minimize not only the risk of double recovery, but also the risk of conflicting outcomes. Mexico, in the same proceeding, stated it is, in its non-party submission, even beyond particular concerns about duplication of relief, the NAFTA waiver provision reflects a concern about the redundancy of proceedings generally. Mexico cited to Waste Management 1 and Thunderbird for this accepted understanding of the object and purpose of the waiver provision. In its submission in that case, Canada stated that it agreed with both the United States and Mexico that the purpose of Article 1121 in NAFTA, the waiver provision, is to avoid conflicting outcomes and legal uncertainty. And they went on to state what you can see on the screen there, to avoid multiple proceedings at the same time and from having to continue to defend against such claims after the arbitration is concluded. And in the submission that the United States of America made just yesterday in this case, it said, it reaffirmed its position that the purpose of the waiver provision is to avoid the need for a respondent to litigate concurrent and overlapping proceedings in multiple forums with respect to the same measure and to minimize not only the risk of double recovery, but also the risk of conflicting outcomes. So we draw at least 3 conclusions from these authorities. First, each investment tribunal and each state that has taken a position on this, at least with respect to the authority that we have in this record, has agreed with Renco's position that the object and the purpose of the waiver provision is to prevent parallel redundant proceedings, double recovery, inconsistent results. Second, no investment tribunal and no state in any submission has stated that the object and the purpose of waiver is to encourage a claimant to resort to local courts before international arbitration. We heard that in Peru's papers and we heard it this morning, and it's flatly incorrect. That is not an object and purpose of the waiver provision. It is not the object and purpose of waiver provisions generally to encourage a party to go to local courts before proceeding to arbitration, and it certainly is not an object and purpose of this treaty, because this treaty has both a waiver provision and a fork in the road provision. We've been focused on the waiver provision, but the fork in the road provision of this treaty affirmatively precludes a claimant from pursuing local claims in the first instance if it subsequently wants to pursue those claims in international arbitration, which obviously Renco does. And I'm going to come back to this important point in just a moment. Third, And most importantly, no authority has suggested that the object and the purpose of waiver is to bar a claimant from asserting claims in a new forum if those claims have been dismissed by an investment tribunal on the grounds of jurisdiction or admissibility. Peru has not cited to a single case, and to our knowledge, no single case exists. Everything about the object and the purpose of the waiver provision in this treaty and another treaty contemplates determinations on the merits. Now, coming back briefly to the argument that I just mentioned, which is under Peru's version, waiver provisions are designed to encourage a litigant to go, or a party to go to local courts first, and that somehow undermines the object and purpose, the actual object and purpose of the waiver, which is not that, but which is to prevent redundant and duplicate proceedings. And they refer to their encouragement to go to local courts first as the no U-turn feature. The only source that Peru cites for that is one sentence in an article by Lee Kaplan and Jeremy Sharp. The United States, in its submission yesterday, mentioned the no U-turn concept, but the United States did not say that it was designed to encourage local proceedings first, and we agree that once a claimant receives a determination on the merits in an international arbitration, there is no U-turn. There's no quarrel with that. But that is a very different proposition than saying what Peru says here, is that the waiver provision encourages people to go to local court first, and if you don't, and then you come to arbitration first, and you're dismissed on jurisdictional grounds, you know, you had your shot at local court, you didn't take it, you have no forum left. With due respect, the Kaplan and Sharp authors are incorrect to the extent they suggest that no U-turn means a claimant is left with no forum, and the premise upon which the authors of that article make the statement, to the extent that that's what they mean, is also incorrect. A waiver is not more flexible than a fork in the road. They both accomplish the same result in different ways. The object and purpose of them both is to prevent multiple lawsuits, parallel proceedings, and double recovery. Fork in the road comes at it from the front end and bars a claimant from commencing an international arbitration if they have commenced a local proceeding. Waiver comes at it from the other end and bars a claimant from bringing a claim locally if the measure of which it complains are already in the process of or have been decided by the international tribunal. But as I mentioned, both of those vehicles have the same object and purpose of preventing the multiple recoveries, multiple lawsuits, and inconsistent results. Waiver does not, on its own, encourage resort to local proceedings. And in fact, as I mentioned a moment ago, Article 1018 of this treaty between the United States and Peru contains both a waiver and a fork in the road clause. Far from encouraging Renco to go to local courts with its investment agreement claim, this treaty barred Renco from going to local courts or to an arbitration under the terms of the stock transfer agreement if Renco wanted to come to international arbitration. We see this in Article 10.18.4 of the treaty. It's in the same Article 1018 as the waiver provision, and it is a quintessential, classic fork in the road provision. It affirmatively precluded and barred Renco from going to local courts first. So I don't understand how they can be arguing that Renco was encouraged to go with respect to its investment agreement claims.
Just to make the point, though, it's a narrower scope, though, isn't it, the fork in the road provision here? I mean, it's picking out investment authorizations and investment agreements,
Yes.
but excluding Section A obligations.
Well, Section A obligations are encompassed in Annex G to the treaty. Annex G is something that the countries can opt into or not, and that will either create a fork in the road for Part A, you know, expropriation, fair and equitable treatment type claims, or not. In this case, actually, the parties did execute G. So between Annex G, which creates a fork in the road for all treaty claims, and 18.4A2, breach of investment agreement, there is a breach of investment authorization, but frankly, our case is all focused on breach of the investment agreement. Between those two and waiver, you have created a perfect circle around inconsistent results and parallel proceedings and the like. And and my point is that this point seems to be overlooked. In fact, together, they do exactly as I said, prevent inconsistent results, overlapping proceedings, and double recovery. Together, they cannot be read to close doors to all fora, which is the way that Peru is reading it. Now, as I mentioned a moment ago, the United States reaffirmed in its submission yesterday the purpose of the waiver provision, and the U.S. did not say in its submission yesterday that it's designed to encourage resort to local proceedings. So the U.S. and Renco are on common ground with that. But the U.S. did make an error in its submission that I need to point out because it touches upon this, and I don't want the tribunal to be confused by it if you pick up on it on your own. In paragraph 3 of its submission, the United States said that Article 1018 does not require a claimant to make an irrevocable choice between domestic proceedings and arbitration, the so-called fork in the road clause. I've highlighted it in yellow. It says, nor does Article 1018 require a claimant to make an irrevocable choice between domestic proceedings and arbitration. With due respect, that's just flatly incorrect. I just showed you Article 1018.4, which does require that choice with respect to investment agreements, which is a critically important part of our case. Now, the U.S. does cite to Annex G, Mr. Landau, as you just raised, and we all acknowledge that Annex G does create a fork in the road for treaty breaches, international law claims. But, you know, as we all know, an investment agreement claim is not in A. That is a breach of contract claim that gives the investor standing to bring the breach of contract claim in a treaty dispute if it meets the qualifications of an investment agreement. And as I said, that's classic fork in the road, and we can't be faulted for not going to local courts with that breach of contract action. And most importantly, as I said, the treaty is not designed to utterly deprive a claimant from any forum, no matter how you look at all of these intersecting provisions of this treaty. Now, I'd like to stop there for a moment and see if you have any questions before I move on to the second reason that we believe Peru's proposed interpretation of the scope of the waiver provision is incorrect. Okay, thank you. Now, the object and purpose of the waiver in the treaty that we just reviewed, the parallel proceedings, inconsistent results, and double recovery, are themselves the means to another object and purpose, which is finality on the merits. And this point is expressed well by the tribunal in Waste Management 2, where it says, no doubt, and this, as you know, is the now Judge James Crawford is the president of this tribunal. He, as you probably know him, he doesn't use the words no doubt very frequently. No doubt, the concerns of the NAFTA parties in inserting Article 1121 was to achieve finality of decision and to avoid multiplicity of proceedings. They go on to say what Article 1120 contemplates is a submission of claims for adjudication on the merits. Thus, again, there's no doubt that in general, the dismissal of a claim by an international tribunal on the grounds of lack of jurisdiction does not constitute a decision on the merits and does not preclude a later claim before a tribunal that has jurisdiction. The same is true for decisions on admissibility. Now, these quotes, as you can see on the slide, are found at paragraphs 27, 34, and 43, respectively, of that award, which is RLA 103. Now, the point here is not that Renco needs to file a second proceeding. It does not. Rather, nothing in its reservation language is inconsistent with the rights that it otherwise possesses under the treaty's waiver language. That's the point that I'm making in this entire presentation. Because a treaty waiver requirement does not apply to dismissal of claims on jurisdictional or admissibility grounds, the additional language that Renco added at the end of it neither adds nor detracts from the scope of the treaty's waiver provision, which Renco has given. In the Waste Management 2 case, as you know, a prior arbitration had been dismissed due to an ineffective waiver, and Mexico argued that NAFTA's waiver provision barred the claimant from being able to commence a new proceeding, even though there had been no ruling on the merits. And like Peru here, Mexico argued that the reason for the dismissal didn't matter. It's dismissed and the reasons are irrelevant. And Waste Management II said no, the reasons are quite relevant. First, the Waste Management II Tribunal focused on the language of the waiver provision and concluded that what Article 120 contemplates is a submission of a claim for adjudication on the merits. The second reason concerned the underlying purpose of the arbitration provision, which the tribunal found was to create effective procedures for resolving disputes, not ineffective ones. And the third was that there's no equivalent rule under international law that would bar the claimant from bringing its claims had they been dismissed without being heard on the merits. And we see a similar type analysis and conclusion by the tribunal in the Murphy versus Ecuador II case, although in a somewhat different context. In that case, the claimant commenced an ICSID arbitration without first complying with the 6-month negotiation period that the treaty required, and the tribunal dismissed the case on jurisdictional grounds. The parties thereafter engaged in the required negotiation process, and when that failed, the claimant filed a second arbitration, this time under the UNCTAD rules, because Ecuador had disavowed the ICSID convention in the interim. Ecuador argued that it was impermissible for various reasons under the treaty, and the tribunal, citing favorably to Waste Management II and its reasoning, disagreed with Ecuador for various reasons, including saying that while the treaty didn't refer explicitly to a decision on the merits, interpreting the treaty under applicable rules of international law mandated a conclusion that a final decision on the merits is what was intended and implied. And the basis of this conclusion was largely the object and purpose of the waiver provision. You see the reference in that quote that I've put on the slide that the tribunal would discuss it in Section C below. When you go to Section C, which is CLA 102, the tribunal went on and explained that one of the objectives of the treaty is to give the investor access to meaningful arbitration, and interpreting the treaty to preclude a claimant from filing claims when they were not heard on the merits in the first forum would be, quote, manifestly absurd and unreasonable under the meaning of Article 32 of the Vienna Convention. And that same reasoning applies here. Peru's no U-turn concept only makes sense if the claimant actually travels down the road of an investment arbitration to resolve its dispute on the merits. In that case, no U-turn is an absolutely fine and appropriate term to use. But if an investment tribunal dismisses for lack of jurisdiction, the claimant has not traveled down the road and there is no occasion for a U-turn. And in that case, the claimant is permitted to travel down a different road. And nothing in the treaty or international law warrants a different result. We heard this morning that Renco can't have its cake and eat it too, and that Renco can't have many bites at the same apple. But Renco isn't asking for either one of those. Renco is just asking for one piece of cake or one bite at one apple. It is Peru that is trying to prevent what the basic tenets of the treaty allow. The third reason that the scope of the treaty's waiver provision does not encompass claims that are dismissed on jurisdictional grounds is that the object and purpose of the arbitration provision is to create effective procedures for resolution of disputes. Interpreting the treaty, as Peru does here, which proposes to leave a claimant with no forum at all, calls for an ineffective system of justice. It would frustrate justice, and the tribunal should avoid such a result if possible. It is trite to say that before the modern era of BITs, there were not particularly effective means of resolving investment disputes. Diplomatic efforts, local court proceedings, and the like were found to be unsatisfactory for resolving investor disputes. We heard my friend across the aisle refer to this reality in his opening remarks when he said we've come a long way in the half century in creating an investor-state dispute mechanism. The investment treaty process was created in part not only to encourage investments in contracting states and help further relations between them, but also with the purpose of helping to create effective means of resolving disputes. There can be little doubt that Peru's proposed interpretation of the treaty, which would leave a claimant with no forum whatsoever, is inconsistent with the goals of creating an effective international procedure. The tribunal in Waste Management 2 summarized this point very well when it said, and I cribbed his words in my introduction, an investor in the position of the claimant who eventually waived any possibility of a local remedy in respect of the measure in question, but found that there was no jurisdiction to consider its claim at the international level, either might be forgiven for doubting the effectiveness of international arbitration procedures. The claimant has not had its NAFTA claim heard on the merits before any tribunal, national or international. And if the respondent is right, that situation is now irrevocable. Such a situation should be avoided if possible. And of course, that tribunal went on to reject Mexico's arguments. We have a similar statement and holding from the tribunal in RDC versus Guatemala. There, one of the respondents' arguments was that dismissal of a single claim on jurisdictional grounds should constitute dismissal of the entire case. Textually, the respondent argued that no claim may be submitted to arbitration without a waiver, meant that all claims must be dismissed rather than each claim for which the waiver was not given. In rejecting that interpretation, the tribunal stated its interpretation respects the rationale and purpose of the waiver to which the respondent has often alluded in support of his arguments, which is that it would not give rise to conflicting outcomes nor double redress. It is also consonant with the objective of CAFTA to introduce effective procedures of dispute resolution. Moving to the fourth reason.
Could I?
Yes, sir.
Forgive me for.
Yes, of
interrupting,
course.
but,
No, I want you to.
Just because
Yeah.
it looks like you're moving on to a slightly different point. Will
Yes.
you at some point be addressing I think there were 4 examples given by Ms. Menaker this morning?
Yes, and I'll do it now. That is not something.
You don't need to. But
I know I'd like to, because it's not something that was briefed. This is not something that's in the written submissions. This example and that argument, I heard it for the first time this morning. And if I understand the argument correctly, and we need to look, if we would, at slide 4 in my handout, because that has the language, and I can probably click to it on the screen. So if I understand the point correctly, the argument is made that Renco is reserving the right to bring some claims in another forum, even if those claims that are dismissed, even if some claims continue on in the arbitration, and that runs the risk of inconsistent results in parallel proceedings. And if that were what we were doing, I would absolutely agree with Ms. Menaker. But that's not what we're doing. There is no possibility under Renco's written waiver that it is going to do, or has reserved the right to do, anything inconsistent with the waiver provision of the treaty. And the text of our reservation of rights is consistent with the statement that I just made. The first part of this waiver comes out of the text of the treaty, the part that's in white. Renco waives its right to initiate or continue before any administrative tribunal under the law of any party or other dispute settlement procedures, any proceeding with respect to any measure alleged to constitute a breach referred to in Article 1016, and that with the exception. And we've been consistent in our briefing that we understand what that means. Measure is different than claim. The treaty waiver provision goes to measure. What we wrote next is, to the extent the tribunal may decline to hear some claims, must be understood and interpreted in the context of this entire paragraph. You cannot take that sentence and that word in isolation without regard to what Renco had just written in the previous statement. What Renco could have done was may decline to hear any claims with respect to any measure alleged to constitute a breach, and that presumably would have eliminated the point. But it wasn't necessary to write those words because Renco had just written them in the sentence before. There are not only was this the intent to not undermine and contradict what it had just written with the second sentence, but canons of interpretation support reading two provisions to be consistent with each other and not inconsistent with each other. And canons of interpretation suggest that a contract should be, or a document should be, interpreted as a whole, not just taking one sentence out of context on its own. Another canon of interpretation is that a document should be interpreted to further its purpose rather than to obstruct its purpose. Those are three very familiar canons to lawyers in the United States. They come out of a famous book written by a United States Supreme Court justice. But they all tie in to the international canon of interpretation called effectiveness. The effectiveness principle summarizes the three general canons of interpretation that I just gave you, that you should not strive to find contradictions in a document. You should not strive to undermine the underlying purpose of a document. And you should read provisions of a document together. And so with due respect, and I'll humbly take this, to the extent that there is ambiguity in that word claims, it is clarified when construed in connection with the sentence that immediately precedes it to be nothing more than exactly what they had written previously in the sentence before, for all the reasons that I'm going through right now in my presentation, which explains that when a matter is dismissed on jurisdictional grounds, it is not something that that the party is precluded from bringing in another forum. In this context, to the extent that the tribunal dismisses a claim on jurisdictional grounds, and that claim is comprised of many measures, but those measures continue in this arbitration in the form of another claim, Renco cannot bring parallel proceedings with respect to those measures that remain in this case. Now, that's a question of material breach. There's no objection. Renco hasn't done any of this yet. This is all contingent upon a dismissal on jurisdiction. All we're focusing now is the construct of what is written there. And what I'm telling you is the second part of that does not contradict, undermine, or conflict with the first part, because subsumed within the word claims is the obvious understanding that it relates to measures that constitute a breach, and Renco cannot pursue them anywhere else.
Forgive me just if I follow up. The way that you've answered that, I've understood, I think, what you've said, but your answer has been premised upon a characterization of what's put against you by the other side,
Right.
as being a situation where there's a finding on jurisdiction and some other claims continue in the arbitration and are determined. And I'm not sure that encapsulates all the 4 points that were articulated this morning. Let me just take one
Yes,
example
please.
and just see how it might work. One example that was given was a situation where a full hearing takes place in front of the tribunal, raising issues of illegality, perhaps amongst other issues. The illegality issue could be a full substantive hearing with witnesses, experts, and there could be a determination by the tribunal on illegality issues, which leads to a conclusion that by reason of a finding of illegality, there is no jurisdiction. Now, in that situation, wouldn't it be open to Renco, because of the qualification to the waiver, to say, well, there has now been a finding that there's no jurisdiction? Could also be admissibility, let's say jurisdiction. And therefore, the way is clear to raise to raise a claim before a new forum.
And because I'm hearing this for the first time today,
Yeah.
I may use the lunch break to formulate.
Sure.
I did my best in the 15 minutes to
Understood.
respond to that. It raises a good point, and again, because we're in a hypothetical situation, and because I'm representing that the language that was added when understood in the construct of the entire paragraph and the purpose does nothing more than whatever the treaty allows. So the debate that we're about to engage in is the extent to which the treaty would allow the person who is dismissed on illegality bring its claims somewhere else.
Yeah.
And that question can come up in any case. What I'm saying is that the words that we wrote does not change whatever that outcome would or would not be.
I'm going to just raise one point, then I'm going to switch the microphone off. Just to complete the point, as I had understood it, the point that's being made is that what's being added here by the qualification are words that don't appear in the treaty, and therefore they may be an attempt to prejudge the issue as to what might be the impact of a
Right.
jurisdiction finding.
Right.
And so the point I think that's being made is that whatever the consequences of a jurisdiction finding may be, will have to be resolved by a subsequent tribunal.
Right.
And all that is permitted at this point is not to tread on that issue, but just to put in the wording that's in the treaty. And therefore that issue will be there, but it'll be something which won't be catered for by wording. It'll be catered for by whatever a subsequent tribunal may say.
That's right. And to continue on that point, we don't disagree. As we wrote in our reply, that the issue of whether or not that question is res judicata or whatever it is for a different tribunal. What we're saying is that we're on the formal defect right now, and the argument is that the word claims there changes what is written before it. And we're saying, no, it doesn't. So whatever the outcome is in that other proceeding, whatever happens in international arbitrations when claims are dismissed on jurisdictional grounds, either happen or don't happen, but it's irrelevant to what we wrote in that last sentence. Thank you. '24, was it? Thank you. So, moving to the fourth reason that Peru's interpretation should not prevail is, again, Renco's interpretation is consistent with customary international law, and Peru's is not. Article 1022 of the treaty that you'll be interpreting and Article 31 of the Vienna Convention both provide that the tribunal should look to principles of international law when interpreting this treaty. I've already shown you the Vienna Convention section. This is Article 1022 2B2 of the treaty itself, which expressly provides that international law may apply. Now, in the context of treaty interpretation, a specific and clear rule set forth in the treaty's text will prevail over other rules of international law. This is lex specialis. But if the treaty's text does not set forth a specific and clear rule applicable to a specific situation, or if the treaty's text as a whole is ambiguous, then otherwise applicable international law will inform the interpretation of the treaty's text so that the treaty is compatible with international law rather than being incompatible with it. The official commentaries to Article 55 of the ILC Articles on State Responsibility address this issue. We cited to it in our written submissions. It's CLA 123. I won't dwell on it. But as the tribunal knows, Judge Crawford is the author of the official commentaries to the ILC Articles on State Responsibility. And as I mentioned, he also, coincidentally, is the president of the Waste Management II Tribunal, which gives that award particular relevance here, especially with respect to the intersection between treaty interpretation and customary international law. As I mentioned earlier, the tribunal in Waste Management II observed that no rule under general international law exists that bars a party from filing a claim in a new proceeding if the claim is dismissed for lack of jurisdiction. And we see this, it's the third reason that the tribunal gave for rejecting Mexico's waiver argument, where they said the third reason is that there is no equivalent rule under general international law. In international litigation, the withdrawal of a claim does not, unless otherwise agreed, amount to a waiver of any underlying rights of the withdrawing party, and neither does a claim which fails for want of jurisdiction prejudice underlying rights. So the point here is to show that under general international law, there is no rule providing that a claim for which fails for want of jurisdiction prejudices somehow the claimant's underlying rights. And because the NAFTA treaty, in this case of Waste Management 2, did not expressly address the issue as lex specialis, customary international law assisted the tribunal in interpreting the treaty to be consistent with principles of international law. And this was the third independent reason why they found that the waiver did not prevent a new filing. Now, Peru argues that Waste Management 2 is an opposite because that tribunal didn't interpret the NAFTA waiver and because the tribunal was not addressing whether the claimant can resubmit claims in any forum after they're dismissed by an investment tribunal, but rather whether it could come back to the NAFTA forum. Firstly, Peru is incorrect when they say that Waste Management did not address the waiver provision. It did. It was stated to be the principal argument that Mexico made at paragraph 26 of that award. But the larger and more significant point is that the substantive reasoning that the Waste Management 2 Tribunal gave for rejecting Mexico's position apply fully in this case, whether it was a refiling at NAFTA once the jurisdictional defect was cured, or if it's a refiling somewhere else. In other words, to agree with Peru in interpreting the scope of the waiver provision here, this tribunal would have to disagree with all of three substantive reasons that the Waste Management Tribunal gave for rejecting Mexico's argument. Fifth and final point on this topic relates and overlaps somewhat with the lex specialis textual point that I just made, and this is a textual point. Peru's interpretation is not only inconsistent with customary international law and the object and purpose of waiver, but it does not account for the structure and the full text of the treaty, and as such, its interpretation would result in a manifestly absurd result. As I mentioned at the outset, and this tribunal knows it quite well, the mechanism for creating an arbitration agreement between a state and an investor is that the state has extended the offer under Article 117, which we heard about this morning, consent of each party to arbitration. The investor attempts to accept that offer by submitting a notice of arbitration under 1016, entitled Submission of a Claim to Arbitration, and importantly for present purposes, satisfying the condition and limitations on consent, which is submitting a waiver under Article 1018. That's a condition precedent to the agreement coming into effect. Peru notes that we agree with that, and we do. It's a question of consent. So here we have Article 1017 and 1018, consent and conditions. In arguing its textual interpretation, which conflicts with the object and purpose of the waiver provision, Peru focuses on, the words any dispute, any forum, but they read the word any in isolation, and they ignore Article 10.17 and the structure. An agreement to arbitrate, as I mentioned earlier, is the only basis for the Investment Treaty Tribunal's jurisdiction. That's obviously uncontroversial. If the state does not agree and consent to arbitrate the claims, there is no arbitration agreement. This is very parallel with the first reason that the waste management decision gave, a textual interpretation. If there is no agreement to arbitrate, the tribunal has no jurisdiction over those claims. No investment agreement, Renco is a French company, whatever the reason for dismissal might be. And when the tribunal dismisses those claims for lack of jurisdiction, that necessarily is the result of the tribunal coming to the conclusion that there was never an agreement to arbitrate those claims because the state didn't consent to them. So in other words, a jurisdictional dismissal of claims that a claimant attempted unsuccessfully to have heard by you on the merits means that the state never offered to arbitrate them and the investor couldn't accept because there was never an offer and there's no arbitration agreement. And if there's no agreement to arbitrate those claims in the first place, the jurisdictionally dismissed claims, then certainly the claimant can't be bound by a waiver that it gave as a condition to the creation of the agreement in the first place. It's a textual analysis. As I mentioned, it's on all fours with the Waste Management 2 analysis, paragraph 34 of that decision, and it's another reason why waiver implicitly or arguably now explicitly assumes adjudication on the merits because it's a condition of consent. I knew that was, I knew that, yeah.
I'm just, it's very short. It just the argument that you're making, as far as I understand it, is to say that there's a sort of circularity, because if there's
I didn't hear the word you used, I'm sorry.
there's a certain circularity.
Yes.
Because ultimately, the position you end up with is if the tribunal has found that there's no jurisdiction, then in a sense there's a nullity. There's nothing there.
Right.
And therefore there can't be anything which is going to bind the claimant.
Right.
But the issue which seems to me, at least at the moment, missing from that analysis is the concept of competence. Because when you consent, when you get into an arbitration process, it has two elements. One element will be the substantive process, but another small element will be the ability of the tribunal, albeit not finally, to resolve its own jurisdiction.
Right.
And in the course of that competence component, it might make findings, for example, on issues such as illegality.
Right.
Or it might make other findings which actually may have some validity, some existence, even if the conclusion is, therefore, there's no arbitration agreement.
Right, so now we're back to that singular
exactly.
question. Okay, good. So let me.
I just wanted to raise it. And
Yeah.
You want to think about it.
No, that's something to think about. So, in sum, Peru is arguing an interpretation of the scope of the waiver that conflicts with the object and purpose. It would create ineffective and a grossly unfair system for resolving disputes, leaving the claimant with no forum. Its proposed interpretation conflicts with general principles of customary international law and would result in a manifestly absurd result when the structure in the text is written and is read together. And for these reasons, we ask that you find the reservation language that Renco included with its waiver does not violate the waiver provision, because that language, as I keep repeating, does not seek to deviate at all from the right that Renco already has under the treaty. It does not seek to expand it or reduce it. It is superfluous. And with that, I'll hand the floor to my colleague, Mr. Weiss, who will address the question of cure.
Thank you. Members of the tribunal, I'm going to focus my presentation by providing a few comments by Renco to the submission of the United States from earlier this week regarding the question of cure, which which Peru embraced this morning. Let me begin by stating perhaps something obvious. The views of the United States are plainly entitled to due consideration. At the same time, investment tribunals have disagreed with non-disputing parties on specific propositions of law. This morning, Peru referenced the fact that in its submission earlier this week, the United States had cited its own prior submission in the GAMI v. Mexico arbitration. And I would simply note as an example of the point I just made that in the final award, that tribunal specifically disagreed with the United States on certain points of law. And here, we disagree with both Peru and the United States on a few aspects of their position with respect to the question of cure. Now here, and unfortunately the colors did not come through, at least in what I'm looking at, I've tried to put different colors on these two sentences from the submission of the United States because I'd like to distinguish a few different components of what is said. First, and this is highlighted in the first sentence in yellow, Renco agrees that the discretion whether to permit a claimant to proceed under an ineffective waiver lies with the respondent. And we also agree that that's a function of the respondent's general discretion to consent. As Mr. Kehoe just said, an effective waiver is a condition of consent, and only a respondent can waive that defect. Now, just a point of clarification, because it was stated a few times in Peru's reply, and it was repeated again this morning. There was the suggestion that one of the arguments that Renco is making is that there is no violation of the waiver so long as there has not been a material breach, and that we had ignored certain arguments. That is not our position. We agree that if there is a formal defect, that is a problem. So, for instance, we agree with the final statement in this sentence where it says a tribunal itself cannot remedy an effective waiver. But, and this is a very important but, we disagree with the second half of the first sentence. I intended for it to be highlighted in green, that the discretion to whether a tribunal can allow a claimant to remedy a formal defect is a separate question. It's not that the tribunal remedies the defect, it's that the claimant represents the defect, and the tribunal has to decide whether or not that is permissible. That is not a function, as suggested here, of the respondent's general discretion to consent. That is actually a power falling within the second sentence, or the first half of the second sentence. The tribunal may determine whether the waiver complies with the requirements of Article 18. To put it differently, the tribunal decides whether the conduct of the claimant complies with what the treaty requires. And to prove my point, I'd like to focus on the authority that the United States cites. And so you see here, in text, I typed footnote 18. And I'd like to turn now to footnote 18. This is from the United States submission. And in that footnote, they cite to RDC, Railroad Development Corporation, and specifically to paragraph 61. And I would note that Peru this morning also cited to that paragraph for the same proposition at PowerPoint slide 47. And in this paragraph, that tribunal declined to allow a respondent to cure a material breach, ongoing domestic arbitrations that tribunal determined were inconsistent with the claimant's waiver obligations. However, and you'll see I've highlighted it there, at the end of the quote in the footnote there is a brackets indicating that something has been omitted from the quote. And I'd like to turn to that. This is paragraph 61 of RDC with the holding that I just discussed. And in that paragraph, the RDC tribunal included a footnote itself in which it expressly distinguishes the holding before it, which concerned material breaches of a waiver, with the holding in Thunderbird, in which a tribunal allowed claimants to cure a formal defect. This morning we heard a citation to several cases, Detroit, Commerce Group, and RDC. And yet here, RDC, an authority on which both Peru and the United States rely, draws the exact distinction that Renco maintains here. Investment tribunals allow allow claimants to cure formal defects as distinct from material breaches. We also heard this morning that Thunderbird is inopposite because there was some ambiguity as to whether or not NAFTA requires a waiver with the notice of arbitration or when it was provided in that instance with the particularized statement of claim. We respectfully disagree with Peru's interpretation of Thunderbird. That tribunal found that there was a defect. The claimant had made a mistake. The paragraphs are there before you. I won't read them to you, but they gave 3 reasons for why they were allowing the formal defect to be remedied. First, the defect was purely formal. Second, not allowing the claimant to cure would be interpreting NAFTA in an excessively technical manner. And third, allowing the claimant to cure would be consistent with the object and purpose of the waiver provision, as well as the larger object and purpose of creating effective mechanisms for the resolution of investment disputes. And this more, I'm sorry, I was just paraphrasing. I was not.
Sorry, I believe we're on slide 34.
34 and
But
35.
the third point you made, it doesn't appear in the text which you have provided to us as such, right? That goes on to 35.
Certain. If it's easier, I can come back.
Purely
with my-
formal, and then excessively technical manner.
And consistent with the object and purpose of the waiver
That
provision.
last bit, consistent with object and purpose, I don't see on 34.
Can I come back to that?
Absolutely, yeah, just so we're all on the same page.
Certainly.
Thank you.
this morning, the question was put to Peru whether if allowing Renco to cure a formal defect would cause it prejudice. And I certainly don't want to mischaracterize the position of Peru, but I understood them to say that that was an irrelevant factor. I did not understand them to articulate an actual prejudice that they would suffer, and I think that makes sense. We have not committed a material breach, and if we waive this right before we ever initiate any proceedings, no harm would ever come to Peru by allowing that. So these three reasons in Thunderbird are equally applicable here. The formal defect at issue in Thunderbird conceptually was worse than any potential formal defect here. In Thunderbird, the claimant failed to waive any right whatsoever with its notice of arbitration. In this case, Renco has waived all of the rights that in good faith it believes it is required to waive. At worst, it has failed to waive a narrow subset of rights, and it has represented that it will immediately waive those rights should this tribunal determine that it's necessary. If I could turn now to the second principal comment that I would like to make with respect to the United States submission on the question of cure, where they suggest that even if a respondent allows a claimant to cure, that the date of submission is the date on which the effective waiver is received. And I have two comments. One is a temporal assumption, and second goes to the concept of cure. We disagree with the unstated assumption that consent must be perfected and jurisdiction vested in every instance the day that the arbitration commences. This is a proceeding governed by international law. Consider Mavramatis. On the day that legal proceeding commenced, the treaty creating the consent of the respondent had not yet entered into effect. On that day, there was no perfected consent, there was no jurisdiction. And on that basis, the respondent argued that the legal proceeding should be dismissed. The Permanent Court of International Justice rejected that argument, holding that they give much more importance to questions of substance over form. The remedy had been cured. And the International Court of Justice has repeatedly endorsed this principle. And if I could focus for 1 second on a holding from the International Court of Justice in 1996, in which they state that it is correct that normally the question of jurisdiction and therefore consent is assessed on day one, but there are exceptions, especially for certain kind of defects. And if it is the kind of defect that a claimant or applicant can easily remedy, the claimant should not be penalized, which takes me back to Thunderbird and the concept of cure. If a claimant is allowed to cure a defect, they are treated as if they complied. Not because they actually complied, there is a defect. By definition, there is something less than what was required. But because they remedied it, they are treated as if they had complied. Consider the language of Thunderbird. Again, the claimant was treated as if they had effectively complied because they had remedied the defect, and their defect did not invalidate the submission. Or consider how RDC characterized the holding in Thunderbird. The conduct of the claimant was sufficient for purposes of the treaty. Now, the United States theory that even if a claimant is allowed to cure a defect, but we're going to treat it as if the arbitration commences on the day of the effective waiver, is not really a cure. You are effectively dismissing the prior claim and treating them as if they've commenced a new proceeding or filed a new claim in the ongoing proceeding. And it's important for us to highlight an aspect of our argument that cure means that we are treated as if we had effectively complied. If Renco filed its claims today, Peru may argue that the claims run afoul of the treaty's 3-year limitations condition. We would, of course, argue to the contrary. But if this tribunal allows Renco to remedy any formal defect and Renco does so, then, like the tribunal in Thunderbird, this tribunal should treat Renco's conduct as if Renco complied with the treaty's waiver requirements from the outset of this arbitration. To conclude, the authority most on point, Thunderbird, holds that claimants can cure formal defects in a waiver, and that's consistent with international law. It's not the tribunal that remedies the defect, it's the claimant. And a cure is equivalent to compliance with the treaty's requirements. Members of the tribunal, no investment tribunal has ever dismissed a claim or a case based on a mere formal defect in a waiver. For these reasons, if this tribunal determines that Renco's waiver contains any formal defect, we respectfully request that Renco be afforded an opportunity to cure that defect.
So I am going to now address the third point of our opening argument, which is that Renco is not asserting enterprise claims. The treaty allows an investor to bring a claim against a state, either on the claimant's own behalf, for its own injuries, for state conduct, or it may bring a claim on behalf of an enterprise that it owns and controls for loss or damage that the enterprise has suffered. If the investor chooses to bring claims only on its own behalf, the treaty requires that the claimant submit its own waiver. The treaty does not require the investor to submit a waiver for the enterprise if the investor is not bringing claims for damages on behalf of the enterprise. On the other hand, if the investor chooses to bring claims on behalf of the enterprise, the claimant must provide a waiver for both itself and the enterprise. It is undisputed that in this arbitration, Renco is asserting its own claims for damages that Renco itself has suffered. Renco is not asserting claims on behalf of the enterprise Doron Peru. Renco has provided the written waiver and has therefore complied with its waiver obligations. Peru calls its argument the de facto argument, and it fails for at least 4 reasons. The text of the treaty is clear, and it expressly provides that no waiver is required for the enterprise when the claim is not brought on behalf of the enterprise, and I'll show you that. Principles of international law regarding flow-through damages is consistent with the text and the structure of the treaty on this issue. Investment tribunals have routinely rejected arguments that are similar to the one that Peru advances here, and principles of corporate separateness under Peruvian law also preclude Peru's de facto enterprise argument. Start, as we normally do, with the Vienna Convention, law on treaties, interpreting it in good faith and in accordance with its ordinary meaning to be given to terms in the treaty in the light of their context and in their light of their object and purpose. And Article 31.4 provides that a special meaning shall be given to a term if it's established that the parties so intended. And this means that defined terms in a treaty should be interpreted in accordance with their definition, which I'll get to in a moment. Now, starting with the text, Article 10.18, Conditions and Limitations on Consent, 2b. Notice of arbitration. No claim may be submitted to arbitration unless the notice of arbitration is accompanied by, for claims submitted under Article 1016.1a, the claimant's written waiver, and for claims submitted to arbitration under Article 1016.1b, by the claimant's and the enterprise's written waiver. So now let's turn to Articles 1016.1. In the event that the disputing party considers the investment dispute cannot be settled by negotiation, the claimant on its own behalf may submit to arbitration under this section a claim that the claimant has incurred loss or damage by reason of or arising out of the breach, and the claimant on behalf of the enterprise of the respondent that is a juridical person that the claimant owns or controls directly or indirectly, may submit to arbitration under this section that the enterprise has incurred loss or damage. So by its express, very clear terms, Article 1016A of the treaty permits a claimant to submit a claim on its own behalf. The treaty provides precise definitions for the terms claimant and enterprise. I won't read them, they're on that next slide. The structure of Chapter 10 confirms this straightforward textual analysis. There are two categories of claims: those that an investor asserts directly on its own behalf, and those that an investor asserts on behalf of its subsidiary. In the first category, the investor must prove damages that it itself has suffered, and in the second category, the investor need not prove damages to itself at all. It can and must prove damage to the underlying local enterprise and quantify those damages. Because Renco is asserting claims only on its own behalf and not on behalf of Doe Run Peru, it must only provide a waiver for itself, and it did so. Now, Peru argued this morning that even though Renco is asserting claims on its own behalf, under 1016A, 1A, which would not require an enterprise waiver, Renco is asserting these de facto claims because the factual allegations overlap between the first arbitration request and the second arbitration request, when in the first arbitration request, Renco was, Doe Run Peru was a party. Peru's argument, based on the similarity of the factual overlapping allegations, is irrelevant to this jurisdictional analysis. The same state measures can give rise to claims under Article 10.1a for the investor himself or 1016.1b for the enterprise. There doesn't have to be different facts for those two types of claims. The facts underlying the wrongful measure remain the same, and they don't somehow convert an investor's claim for damages to itself into a de facto claim for damages to the enterprise. The compensation to which the claimant will be entitled regarding the claims for damages to itself under 16.1a may not necessarily be the same as compensation to which the enterprise would be entitled if it had had a claim and brought it. Again, it's not a question of jurisdiction. Under the clear language of the treaty, this is a question of quantum that will be taken up, which is a third phase in this arbitration. We have jurisdiction and liability next, and quantum is after that. Now, the second reason that Peru's argument on de facto enterprise fails is that these types of claims are common in investment treaty arbitrations. The form of compensation is referred to as flow-through damage. The text and the structure of the treaties have been designed in the wake of Barcelona Traction, as Ms. Menaker mentioned, to allow for such claims. Professor Dolzer and Schroyer describe this in their treaty, their somewhat famous treaty, Principles of International Law, which we have included as CLA 97. And they explain that most investment treaties offer a solution, even though the local company may be unable to pursue claims internationally, which is the case here. The foreign shareholder in the company may pursue the claim on its own, in its own name, and the shareholder then may pursue claims for adverse action by the host state that affects the value and profitability. Arbitral practice illustrating this point is extensive. That's what they say, and they cite to 17 awards which prove this flow-through damage theory. Now, as Renco explained in its reply memorial at paragraph 38, the flow-through damages calculation does not deny legitimate creditors payments of their claims. The flow-through damages analysis takes into account the local enterprise's indebtedness to creditors, and that's what's meant by flow-through to a large degree. And Rapinski and Williams explain this fact in their treaty, and other investment treaties have explained this relatively uncontroversial fact as well. We've cited to all of them in paragraph 45 of our counter memorial on waiver. Now, I think it will be helpful now to look at Renco's claims in this case so that we're not analyzing this issue in a vacuum. The first two claims that Renco asserts in this arbitration relate to the St. Louis litigation and Peru's refusal to take responsibility, financial responsibility for those lawsuits. These are direct claims by Renco that are completely unrelated to Peru's mistreatment and expropriation of the local enterprise in Peru. Those are completely direct. Now, the next three relate to Peru's unfair treatment and ultimate expropriation of the local Peruvian enterprise, Dorum Peru. Renco summarizes its expropriation claim at paragraph 387 of its memorial, for example. And what it says is that in the present case, and again, this is in its memorial, Peru's actions and omissions towards Renco's ownership interest in the La Roya complex embody the hallmarks of both types of expropriation. Renco has been totally deprived of its investments, just as in the classic case of direct expropriation, and Peru affected that taking by a series of measures that indirectly deprived Renco of the benefits of its investment and its incidence of ownership. The indirect expropriation of a corporation is an example of a direct loss sustained by an investor, and this goes to Mr. Landau's question from earlier. It's an example of a direct loss sustained by an investor that gives rise to a claim by an investor on its own behalf under Article 1016(1)(a). It is a harm to the investor that results from actions and measures that the state takes against the local enterprise. The submission by the United States government yesterday supports this relatively uncontroversial fact. It says, examples of direct losses sustained by an investor that would give rise to a claim under Article 1016(1)(a) include wrongful expropriation of the shareholder's ownership interest, whether directly through expropriation of shares or indirectly by expropriating the corporation as a whole. That fits squarely within what we're saying is our Article 1016(1)(a) claim. And the other claims are related. They're different heads of the same coin. Renco's ownership interest in the corporation in Peru is gone, has been taken from it by the state. Now, there's no mention here in the U.S. submission or anywhere else about an investor's percentage ownership in the expropriated investment. That is irrelevant to the jurisdictional analysis. If an investment has been expropriated indirectly or directly, the investor may claim the resulting damages under 1016(1)(a). The percentage ownership argument is a straw man. It has no logical or legal reasoning to it. The third reason that Peru's enterprise argument fails is that several NAFTA tribunals have already rejected the very same type of argument. In view of the Pope and Talbot Tribunal, they say, in view of the tribunal, it could scarcely be clearer that claims may be brought under Article 1116 by an investor who is claiming for loss or damage to its interest in the relevant enterprise, which is a juridical person that the investor owns. In the present case, therefore, where the investor is the sole owner of the enterprise, sole owner, which is a corporation, and thus an investment within the definition contained in the articles, it is plain that a claim for loss or damage to its interest in that enterprise or investment may be brought under Article 116. But for immediate purposes, the important point is that the existence of Article 117 doesn't bar bringing the claim under 116. And of course, 116 is the investor claim under NAFTA, and 117 is on behalf of the enterprise. UPS versus Canada, similarly, Canada made an argument that is similar to the one Peru advances here. The tribunal summarized Canada's argument as follows, and I do hate to read slides, but these are just very much on point. Canada urges us to find that the tribunal lacks jurisdiction because UPS brought its NAFTA claims under Article 116, respecting harm to investors, rather than 117, respecting harm to the investment. In brief, Canada's argument is that any harm flowing from the conduct complained of primarily affects the enterprise. The tribunal rejected Canada's jurisdictional objection and held that UPS had brought claims properly on its own behalf under Article 16, and it owned 100% of the enterprise. Now, Peru argued this morning that the tribunal's decision in that case is not persuasive because it concluded that in the context there was no substantial difference between the claims filed in 116 versus 117. But that's not the point of the UPS decision, irrespective of what damages a tribunal may or may not award in the future, whether flow-through equals the underlying harm to the investor or not, is irrelevant to the jurisdictional question. An investor is permitted to seek damages on its own behalf under the treaty, as this esteemed tribunal held. And in fact, they held it on the next slide. Whether the damage is directly to UPS or directly to UPS Canada and indirectly to UPS is irrelevant to our jurisdiction over these claims. That is clearly the same position taken by the tribunal in Pope and Talbot. And we submit that as the correct position. Now, similarly, Peru argues that because the claimants had provided waivers on behalf of the enterprise in the Mondev case, the Mondev tribunal said it was immaterial that Mondev had not asserted an enterprise claim because they were arguing they had to for some reason. And the tribunal said, no, they don't. But Peru argues that this is meaningful because Renco has not provided a waiver for its subsidiary. What was its subsidiary? But this argument also misses the mark because, again, and I do think this was explained fairly, NAFTA has a glitch in it which requires submission of a waiver by the enterprise even if the investor is not bringing a claim on behalf of the enterprise. So it's a little odd, but in Mondev they explained they gave the waiver for the enterprise because the treaty required them to, but that doesn't mean that they had to bring the claims on behalf of the enterprise. And the treaty drafters, after NAFTA, fixed this little confusion and made the CAFTA treaty and this U.S.-Peru treaty much more clear. You don't have to give a waiver for the enterprise if you're not bringing claims on behalf of the enterprise. But Peru is trying to shoehorn the NAFTA confusion and the change in the treaty language to its own benefit when exactly the opposite is the case. The treaty was clarified to say exactly what the Pope and Talbot and the UPS tribunals said. An arbitral precedent interpreting the CAFTA treaty, which has the identical language to what we have here, we see in Teco versus Guatemala. And that was an American corporation, indirectly owned shares in a Guatemalan company, and Teco asserted its claims under 1016A. It did not assert claims under 1016B. It provided a written waiver on behalf of itself. It didn't provide a written waiver on behalf of its subsidiary, and it sought damages that it itself suffered, and it calculated and received, actually, in the damages phase, the flow-through damages. The tribunal admitted the claims and ruled in Teco's favor on a flow-through analysis. The fact that Teco did not own more than 51% of the shares was not a relevant part of the analysis. Peru's argument is that somehow the entire text and structure and arbitral precedent changes if the investor owns 51% versus 49% for jurisdictional reasons. And there's no basis for that. Absolutely none. They have cited to none because there is none. That brings me to the final reason that Peru's de facto enterprise waiver theory fails. Peru argues that somehow Renco is doing an end run by having Do-Run Peru engage in parallel proceedings, which A, is not the case, as you're going to hear from Mr. Burnett. These local proceedings are defensive in nature, and he'll explain that. But Peru's argument also runs afoul not only of the treaty text and the defined term claimant and enterprise, but also well-grounded principles of corporate separateness that are fundamental to many civilized laws, including Peru's civil procedure and corporate law, which we've attached as Exhibit 159, Article 78. A legal entity has an existence distinct from its members. So Peru, its argument implicitly treats Renco and Do Run Peru as if they're the same juridical person, which is inconsistent not only with the text of the treaty, but with the laws of Peru. So in sum, on this point, members of the tribunal, the text of the treaty and all authorities in the record in this arbitration, including treatises, arbitration awards, academic articles, the submission yesterday by the United States on expropriation of a wholly owned company, confirm Renco's position that it may bring claims on its own behalf and it not necessarily have to bring claims on behalf of its enterprise, and that a waiver for the enterprise is not required because Renco has brought treaty claims on its own behalf. Now, I'm happy to answer any questions. If you don't have any, I will turn the floor to Mr. Burnett. Yeah.
Thank you. Let's proceed. Thank you.
Good afternoon, members of the tribunal. I'll cover two additional points during my presentation. First, I'll discuss the actions of Do Run Peru related to the involuntary Do Run Peru bankruptcy proceeding pending in Peru, which Do Run Peru did not initiate or continue. I'll demonstrate how Do Run Peru is merely defending itself against claims asserted against it, and that these defensive measures fall outside of the ambit of Article 1018. As I will explain, and as we have set forth in our submissions, the right to defend oneself, even in light of a waiver clause, is consistent with the treaty, customary international law, and basic tenets of due process. In the government submission we received yesterday, they clearly agree. Second, I will demonstrate that Renco, as Renco has in its submissions, that even if the tribunal determines that Do Run Peru's defensive actions somehow violate the waiver requirement, Renco's claims still stand. The discussion of these 2 points, however, is moot if the tribunal determines, as we respectfully assert that you should, that number one, Renco's waiver is valid, or that the minor defect is such that the tribunal determines it can, in the interest of justice, be fairly remedied. And two, Renco is asserting only 1016(1)(a) claims on its own behalf and not de facto enterprise claims on Do Run Peru's behalf under Article 1016(1)(b). I submit my colleagues have ably demonstrated both. So I'll now turn to my first point. And what I would encourage the tribunal to do is turn to page 69 of Peru's submission, which is entitled "The Plain Facts," and just keep. Pardon me.
PowerPoint.
Their PowerPoint. Page 69, yes. How much time I have? You've got 25 minutes. Okay. Now, Peru labeled this slide "the plain facts." However, it omits many facts and many events in the Do Run bankruptcy proceeding prior to what Peru calls the first proceeding, which is the constitutional amparo. In addition, I think it's noteworthy that this graphic does not use the word bankruptcy once. I submit that that is not an intentional oversight. So in an effort to create a new reality regarding the proceedings related to Do Run Peru's bankruptcy, and in an effort to try to convince the tribunal that Doe Run Peru was not acting defensively in response to Peru's claim asserted against it, Peru mislabels the constitutional amparo filed by Doe Run Peru on November 22nd, 2010, in response to the Ministry of Energy and Mines' $163 million credit claim as the first proceeding, and the contentious administrative action Doe Run Peru filed on January 18th, 2012, which is merely a continuation of its initial challenge of the government's credit claim filed in September of 2010 as the second proceeding. Peru adopts these labels in order to create the impression that the actions are something other than they are. Peru describes them as affirmative actions initiated and continued by Doe Run Peru, and not defensive actions in response to claims made against it by Peru in the bankruptcy proceeding. As we've heard more than several times this morning, Article 1018 requires that a claimant submit a waiver of any right to initiate or continue before any administrative tribunal or court under the law of any party, other dispute settlement procedures, any proceeding with respect to any measure alleged to constitute a breach referred to in Article 1016. I submit that the relevant proceeding for purposes of this analysis is the Doe Run Peru involuntary bankruptcy proceeding. Doe Run Peru did not initiate or continue this proceeding. Rather, it is the subject of the proceeding as debtor in possession. Also, since May 22nd, 2012, Doe Run Peru has been controlled by two separate liquidators who make decisions believed to be in the best interest of the debtor. Debtors in possession, meaning company management, have duties and responsibilities under Peruvian law which are consistent with the duties and responsibilities of subsequently appointed administrators or liquidators. These responsibilities include protecting the integrity of the bankruptcy estate and acting in the best interest of the creditors, not favoring one creditor over another. One such responsibility in any bankruptcy proceeding is to investigate and, if necessary, defend against potentially invalid credit claims. Defending against a claim does not violate the waiver requirement, especially when, like here, Doe Run Peru and later the liquidators had no meaningful choice but to do so. Peru incorrectly argues that the fork-in-the-road jurisprudence is inapplicable to determinations to waiver. Peru tries to distinguish fork-in-the-road and waiver by arguing that fork-in-the-road requires a choice between two proceedings and waiver does not. Of course, they both require a choice. It's simply a matter of timing. Nothing Peru has said in support of its argument that fork-in-the-road cases are inopposite to this analysis supports its position that those cases are of no use. Requiring a claimant to give up its defensive actions related to a claim asserted against it would serve no purpose and would be fundamentally unfair. Determining that defensive actions do not violate the waiver is also not inconsistent with the object and purpose of both the fork-in-the-road and waiver requirements, which is, as we've heard several times, to avoid parallel proceedings, double recovery, and inconsistent results. Both waiver and fork-in-the-road are designed to prevent claimant from having two bites at the apple. Certainly a bankrupt debtor defending its assets from claims asserted against its estate is simply not the kind of scenario either doctrine was meant to address. The fact that the defensive actions are not all exactly the same from a procedural standpoint should not drive this analysis. Rather, the nature of the action should. Peru has not cited one case, because no such case exists to my knowledge, for the proposition that a debtor in possession in an involuntary bankruptcy proceeding cannot defend itself against a credit it believes is illegal because it would violate the waiver or fork-in-the-road requirement. Indeed, to find otherwise would wreak havoc on the bankruptcy process to the detriment of creditors whose rights are of paramount importance within the bankruptcy process. Indeed, fork-in-the-road cases strongly support Renco's position that defensive actions do not violate the waiver. Oops. In Occidental versus Ecuador, like here, the investor affirmatively filed 4 lawsuits in tax court in Ecuador, objecting to resolutions denying all further value-added tax reimbursement applications. If the investor had not filed its objections to the resolutions within 20 days, its right to object would be forfeited. The tribunal in Occidental concluded that it is of the view that in this case the investor did not have a real choice. Thus, in Occidental, a claimant commenced challenges to a new tax law which, if not challenged, would become final and binding. It was therefore defending against a claim. Here, too, as we will see, if Doe Run Peru had not challenged the ministry's credit within 10 days, it would have almost certainly been accepted by Indicopy. In the third interim award on jurisdiction and admissibility in Chevron, which is CLA 084, the tribunal found that defensive measures did not trigger fork in the road, and stated that that fork in the road does not extend to the raising of a defense in response to another's claim submitted to that court. The same holds true for the decision in Enron versus Argentina, which involved a similar situation to Occidental, where the investor or its local entity actually commenced the action. Finally, in the decision of the tribunal on objections to jurisdiction in CMS versus Argentina, which is RLA 129, the tribunal rejected Argentina's fork in the road objection based upon, among other things, the fact that the court's decision appealed by the local enterprise related to judicial proceedings initiated by the Argentine ombudsman, and in which the local entity had only intervened as a third party. And the tribunal found this to be defensive and reactive actions. This case is most like Occidental versus Ecuador in the following sense. As I'll discuss in a moment, Doe Run Peru had no real choice but to oppose Peru's $163 million credit claim against its estate. It had only 10 days to do so, or the claims would be recognized. Failure to do so would violate Doe Run Peru's obligations under Peruvian law. I should note that the U.S. government seems to appreciate that acting defensively against claims would not violate the treaty's waiver requirement. In yesterday's submission, the State Department said, whether a claimant has initiated or continued a proceeding as opposed to merely defending a claim depends on the specific facts and circumstances presented. The specific facts and circumstances here, as laid out in Renco's submission, and which I will discuss briefly below, demonstrate that Doe Run Peru was merely defending a claim. It was defending a $163 million credit claim, asserting against it in the Doe Run Peru involuntary bankruptcy proceeding. As such, the waiver requirement is of no moment. Now, Peruvian law, like most jurisdictions, required debtors in possession and liquidators, administrators, to act with accuracy, probity, faithfulness, and good faith. As I mentioned, investigating and contesting credits that appear invalid comports with these duties. Not challenging such credit, ensuring its recognition, on the other hand, to the detriment of the creditors, does not. And I've cited several sources of Peruvian law that I will not read the slides, but they're at C-208, which is the Peruvian General Bankruptcy Law. In fact, all of them are part of the Peruvian General Bankruptcy Law. So it's clear that the bankruptcy law in Peru, like many developed countries, imposes special duties on those charged with acting on behalf of a debtor. So as an initial matter, there's no question that the Doe Run Peru bankruptcy is an involuntary bankruptcy proceeding. Peru's arguments to the contrary are simply inaccurate. And there is also no dispute that Doe Run Peru did not initiate or continue the involuntary bankruptcy proceeding, and it cannot stop it. In its reply, Peru appears to argue that the bankruptcy is not really an involuntary bankruptcy because Do Run Peru actually caused its own bankruptcy. Do Run Peru did not cause its own bankruptcy, quite the contrary. However, arguments regarding the reasons Do Run Peru was pushed into involuntary bankruptcy and marshaling facts regarding the events leading up to it is what the merits of this arbitration is all about. Indeed, in Renco's memorial on liability, Renco explained in detail with exhibits, witness testimony, Peru's many breaches. This is not the time for Peru to try to rebut Renco's allegations in its memorial on liability. So despite these multiple red herrings as set forth in Renco's submission and described below, there's no doubt that the Do Run Peru bankruptcy is an involuntary one. Now, I believe that a review of some of the key events related to the Do Run Peru bankruptcy is important for the tribunal to keep in mind, because when put in its proper context and compared to slide 69 that Peru has proffered, it's clear that Peru is avoiding the conclusion that's inescapable that Do Run Peru was simply defending itself, even though it commenced the amparo, and even though it filed an administrative contentious action, which was simply the only way it could challenge the Indicopy Tribunal's final decision accepting the ministry's credit. So as explained in our submissions, on February 18th, 2010, and this is not included on the plain facts slide, 14 months before Renco's notice of arbitration, one of Do Run Peru's creditors filed for Do Run Peru's involuntary bankruptcy before Indicopy. This document appears at Exhibit C-119. I just want to give the tribunal the references to these documents which are in the record. Indicopy is a large state agency of the Peruvian government with jurisdiction over several areas of the economy, including bankruptcy matters. It's also part of the executive branch of the Peruvian government. Indicopy declared Do Run Peru to be in involuntary bankruptcy on July 14th, 2010. This is Exhibit C-206. And Do Run Peru's bankruptcy proceeding was officially commenced on August 16th, 2010 by publication of the notice in El Peruano, which is the official gazette. This publication appears at Exhibit C-207. Peru filed its application to be recognized as a creditor in the Do Run Peru bankruptcy proceeding on September 14th, 2010, 7 months before the filing of this arbitration. The Ministry of Energy and Mines petition to Indicopy is Exhibit C-208. None of the events that I have just discussed and laid out with citations to the record, including the next one, are on the plain facts chart, and it will become obvious why. On November 12th, 2010, within 10 days of receiving notice of Peru's application to Indicopy, and pursuant to Article 38.1 of Peruvian General Bankruptcy Law, Do Run Peru filed its opposition to recognition of Peru's credit before the Indicopy Commission. The Indicopy Commission is the first level of Indicopy, and the second level is the tribunal. Renco's opposition papers are at Exhibit C-207 and Exhibit C-210. Thus, right off the bat, we can see that Peru's characterization of the administrative contentious action of January 18th was not a standalone lawsuit filed by Do Run Peru, but was started with the filing of the government's claim and Do Run Peru's challenge before the arbitration was commenced. Thus, as we have said, the proceeding, for purposes of this Article 1018 analysis, is the involuntary bankruptcy proceeding. Within that proceeding, Peru took action against Do Run Peru. If Do Run Peru had not challenged the credit, which it believed was invalid under Peruvian law, the credit would have been recognized. Thus, Do Run Peru had no meaningful choice but to act in its own defense. So the Ministry of Energy and Mines in September files a credit claim in the bankruptcy against Do Run Peru. They oppose it November 12, 2010. And then on November 22nd, 2010, after submitting its challenge, Do Run Peru commenced the amparo proceeding, which Peru mischaracterizes as the quote-unquote first proceeding. It's simply not a first proceeding. This was simply a separate but complementary means of defending the bankruptcy estate and creditors from what Do Run Peru considered to be an invalid credit under Peruvian law. Peru characterizes the amparo as the first proceeding, which is misleading. Peru's claim that the amparo is neither defensive nor filed in conjunction with Do Run Peru's challenge to the ministry's credit before Indicopy is simply wrong. A constitutional amparo is a well-recognized way to defend oneself in a bankruptcy proceeding. It is also a means by which to obtain interim injunctive relief in an Indicopy proceeding, which can be sought, but only if the first-level constitutional court accepts the petition from a procedural standpoint. That did not happen here. The first-level Peruvian constitutional court did not accept Do Run Peru's amparo petition declaring that it was improcedente or procedurally improper. They did this, and it's explained in our submissions, because they determined, or the first-level constitutional court determined, that there was no threat that Indicopy would actually recognize the ministry's credit because it has no basis in the law. So had Do Run Peru's amparo been accepted, it would have been able to move for interim measures and prevent the ministry from voting in the bankruptcy proceeding. Now, I've cited, I don't want to go into too much detail, but I've cited some authority for the proposition that the insolvency law contains specific provisions in order to restrain actions of creditors or debtors through courts. And as it says in the Exhibit C-223, which is a survey of Peruvian bankruptcy law, this is particularly through the commencement of constitutional proceedings such as the amparo proceeding. So, with all due respect, Peru's characterization that the amparo proceeding is somehow disengaged from the Peru bankruptcy, the Do Run Peru bankruptcy, and does not constitute a defensive act is not well taken, nor is its characterization of the contentious administrative action as somehow some sort of lawsuit that is filed out of the blue in January of 2012. That is also not well taken. They are both part and parcel of Do Run Peru's defense of itself against the ministry's $163 million credit. Now, I'll try to expedite this because I think I've made my point, but it should be noted that in February of 2013 and 2011, prior to commencement of the arbitration, the Indicopy Commission rejected the ministry's credit. The Indicopy Commission stated that the applicable legislation does not establish if the PAMA projects are not completed or if their goals are not met, an obligation arises in favor of the MEM, made up of the value of the incomplete project. It also does not establish that the MEM should execute the last phase of the PAMA project. So on March 7th, the ministry appealed the Indicopy Commission's rejection, which is at C-212 in the record, and then shortly after that, this arbitration was commenced. But by this time, Do Run Peru had successfully challenged the ministry's credit, which was rejected by the Indicopy Commission. It could not be more clear that Do Run Peru, as debtor in possession, had no real choice but to continue with its opposition of what it considered to be an ill-founded credit claim that violates Peruvian law. So in May 20th, 2011, Doe Run Peru opposed the appeal. Several months after, the amended notice of arbitration was filed, and shortly thereafter, November 18th, 2011, the Indicopy Tribunal reversed the Indicopy Tribunal's rejection of the MEM credit claim, which provoked, as set forth in our papers, a very sharp dissent by one of the tribunal members. So it was at this point in time that Doe Run Peru, 1 year and 5 months after the official commencement of the Doe Run Peru bankruptcy, and I will call it appealed, in effect, the decision of the Indicopy Tribunal. As set forth in Renco's rejoinder, the notice from the Indicopy Technical Secretary, which Counsel for Peru referenced, reads at the bottom, let's see, this resolution may be appealed before the judicial power by way of a contentious administrative process within a term of 3 months following notice thereof. What? Okay, so I was told that I have very little time left.
3 minutes.
3 minutes. Okay. After this, a liquidator was appointed, and the ministry actually asked the court in the contentious proceeding to recognize the liquidator as the new legal representative of Doe Run Peru. So I think it's beyond doubt that the Amparo and that Doe Run was simply defending the Doe Run Peru estate, bankruptcy estate, in these proceedings. So even if the tribunal retains, even if the tribunal determines it's not, the tribunal retains jurisdiction over Renco's claims. As set forth in Renco's counter memorial, section 5A, paragraphs 112 to 119, chapter 10 of the treaty uses the term claim consistently to mean each claim, cause of action, a claimant asserts during an investment dispute. The claims are based on measures which is defined as any law, regulation, requirement, or practice. Now, without going into too much detail, because Peru really kind of skated over it and didn't address it, RDC Guatemala tells us, RDC versus Guatemala tells us that partial overlap between the arbitration and other proceedings results at most in only a partially defective waiver and should not result in dismissal of the entire arbitration, as Peru asks here. In that case, RDC had asserted 2 claims in 2 domestic arbitrations, and these 2 measures were also related to RDC's claim in the investment in the CAFTA arbitration. The RDC tribunal refused to dismiss the arbitration as a whole, but instead permitted RDC's claims to go forward as long as they were made up of other measures that were not at issue in the local proceedings. In permitting RDC's fair and equitable treatment claim to stand because it was comprised of measures beyond those at issue in the local proceedings, the tribunal found that that fair and equitable treatment is a general and wide-ranging standard of treatment that may cover claims based on other measures taken by respondent beyond those at issue in the local arbitrations. The tribunal in Detroit International Bridge, which I will not quote, basically stands for the same proposition. The tribunal in Commerce Group as well said the same thing, that RDC stands for that it agreed with claimant's characterization that RDC stands for the proposition that a partial overlap of claims between CAFTA arbitration and parallel proceedings cannot render a CAFTA waiver invalid in its entirety. Again, we note that the United States government in yesterday's submission cites approvingly the language of Commerce Group and says, as the tribunal and Commerce Group observed, the waiver provision permits other or concurrent or parallel proceedings where claims relating to different measures at issue in such proceedings are separate and distinct, and the measures can be quote-unquote teased apart. So I'll close with this. In the event that the tribunal determines that Doe Run Peru's defensive actions violate the waiver requirement, Renco's claims related to the St. Louis lawsuits and Peru's failure to assume liability for those the costs of those lawsuits should proceed because they're based on measures completely separate and distinct from the one issue in the local proceeding, which is the recognition of the Ministry of Energy and Mines credit under Peruvian law. In addition, the other claims, which we've referred to as the taking without compensation claims relating to the mistreatment of Renco's investment, Do Run Peru, should also move forward because they are comprised of many discrete acts or measures that on their own stand without reference to the sole issue, the sole measure in the bankruptcy proceedings, which is the legality or illegality of the ministry's credit. Thank you very much.
Thank you, Mr. Burnett. Mr. Keogh, words in
No
closing?
concluding remarks. We're right at the time, and we're happy to take the lunch break now if that pleases you.
Very good. All right, let's do that then. I have a question. Do we need a full hour, gentlemen? 45 minutes, would that work? Or?
45
Yeah,
minutes is
just so
fine.
that you have a full time for your replies. Yeah, so it's now 1:45 by my watch, although that's a bit fast. So around 2:30, could we say
2:30 it
that?
is.
Thank you very much.
Thank you.